Thank you. Order. Urgent question. Debbie Abrahams.
To ask the Secretary of State for Work and Pensions to make a statement on the Supreme Court's ruling of the 9th of November on the under-occupancy charge.
The Secretary of State for Work and Pensions, Secretary Damian Green.
Mr. Speaker, the removal of the spare room subsidy was introduced in April 2013 to all working-age claimants in the social rented sector as part of this government's plan to create a welfare system that's fair for those who use it and for those who pay for it. Before then, under the previous system, the taxpayer had to subsidise benefit claimants to live in houses which were larger than they needed. This was despite the fact that people who rent in the private sector already received housing benefit based on the number of people in the household rather than the number of bedrooms they have. This has been the case since 1996. Since we introduced the policy, it saved over £1.5 billion, and the number of households affected by the policy is going down. We, of course, operate a number of exemptions to the policy, and these include all pensioners, households with a dependent child receiving the middle or higher rate care component in DLA, households where an overnight carer is allowed for the claimant or partner, households where the claimant or partner is a foster carer, and households with an adult child who is in the armed forces and who is deployed on operations. In addition, we provide local authorities with funding to provide discretionary housing payments to claimants that they evaluate as needing additional support with housing costs. Turning to the Supreme Court's judgment last week, it's welcome that the Court found in our favour in 5 out of the 7 cases. These were cases relating to a panic room, a claimant with mental health issues, those requiring an extra room to house medical equipment, or for shared care and adapted properties. The Court also agreed with our view that discretionary housing payments are generally an appropriate and lawful way to provide assistance to those who need extra help. In the 2 specific cases where the Court did not find in our favour, we will of course take steps to ensure we comply with the judgment. In most cases, local authorities are best placed to understand the needs of their residents, which is why, by the end of this Parliament, we will have provided them with over £1 billion to provide that support. This ensures that people in difficult situations and those who are vulnerable don't lose out.
The Abraham.
The Supreme Court's judgment on Wednesday clearly stated that the bedroom tax is discriminatory, as this side of the House has repeatedly highlighted. The Court upheld the claims of Jacqueline Carmichael, who is disabled and cannot share a room with her husband Jason, as well as that of Paul and Susan Rutherford, who care for their severely disabled grandson Warren. I would like to pay tribute to them, as well as the other families, for their courage, tenacity and determination pursuing these cases. The ruling states that housing benefit regulations allowing claimants to have an additional bedroom where children cannot share a bedroom because of a disability should be extended to adults. Likewise, adults who need an extra room for an overnight carer who have been exempt from the bedroom tax, but children such as Warren have not. These anomalies, the judges ruled, were manifestly without reason. The Department spokesperson has indicated that the Government accept the Supreme Court's ruling. Can the Secretary of State confirm that his department unequivocally does so? Will he let this House know how much taxpayers' money has been spent in total on legal fees attempting to defend the Government's bedroom tax policy? How many families does the Department calculate have been affected by the Government's unlawful imposition of the bedroom tax on disabled people and their carers? When and how will the Government inform the families affected by this judgment? How quickly will the Government comply with the Supreme Court's judgment and revoke the bedroom tax for these families? And will such a revocation be updated, and if so, when? Will the Government now formally apologise for the pain and suffering inflicted on disabled people and families caring for a disabled child? And finally, will the Government undertake to look again at their policy on safe rooms for victims of domestic violence, which affect a relatively small number of incredibly vulnerable women who live in their lives in fear and are being punished by the Government for heeding security advice and being safe in their homes?
First of all, I'm happy to repeat what I said in my statement, that of course we accept the view of the Court, and we will, in answer to some of her subsequent questions, take the appropriate action as soon as we practically can. She also said that the removal of the spare room subsidy was unlawful. It patently isn't unlawful because of the 7 cases before the Supreme Court, they found in the government's favour in 5 of those cases. And what's interesting is that every one of those cases, all 7 of the cases, were receiving discretionary housing payments. These are the best way to ensure that those who are affected by this, if they need help, can be helped. Discretionary housing payments are up 5 times since 2011-12, and the government is committed to another £870 million worth of discretionary housing payments over the next 5 years. And I'm surprised that the Honourable Lady is complaining about them from a sedentary position, because her own local authority received the best part of £500,000 in discretionary housing payments this year. So it is clear that in her own area people find them very useful. She might also be interested to know that those who are affected and who are unemployed, of those 63% have decided to look for work, which I think shows one of the effects of this policy. And I hope she will address the basic issue of fairness, which is that without this, neighbouring households could be treated differently, and I think many people would regard that as unfair. She made the point about those receiving disability benefits. I would point out, as I say, that all 7 of the cases were people receiving discretionary housing payments, and of 4 of the 5 people whose cases were won by the government, 4 of those have a disability. So it is clearly not unlawful. Her basic analysis of this is wrong. And of course the government is spending £50 billion a year on disability benefits, showing that absolutely we want to have a practical system that cares for people with a disability, and that this court case does not alter that at all.
Justin Tomlinson.